guys. Hopefully, I am being heard. Let's do a sound check. One, two, three, ABC. Anybody home? Can anyone hear me? Can I get a yes, please? ABC. Anybody home? Can anyone hear me? Can I get a yes, please? Thank you. Awesome. Welcome, you guys. We're going to get started here. It'll be about 2 minutes and then we'll get going. We have a lot going on today. I just want no, we can't hear you. You can't hear me, Johnny? You're the only one, though. Roger and Lulu and Wendy heard me. Sounds good. Thanks, BB. All right, you guys. Today, of course, at 3 o'clock, we'll come out with, I believe it's part 5 that's coming out on the Daily Ma'am read. So that's exciting. Yeah, I get it, Roger. Thank you. And then we have the big surprise tonight. So the big surprise is going to come out at around 7 p.m. on Central Time for the United States. And it is, I can't tell you any more than why would Brendan say what he said. So, all right, guys, I'm going to go ahead and do a visual check here. Let's get the motion up. And we have the motion posted for the link, so you may have to scroll up. But can everybody see this plaintiff versus Stephen Avery? Yeah, I got kind of into it a little bit. So we'll roll back up. It's a cold read because it just came out. So I'm probably going to stutter a bit. Yep, I can see it on the screen as well. Hi, Emma. How are you? Yep, we've got visual as well. All right, we're at 21 now. We're going to give it just about 2 minutes. Give me a chance to get a drink and get ready here, and then we will go. So, with that, let's go find something to do for 2 minutes while we get everybody in their seats. If you need to go to the restroom before we start, this document, I believe it's 72 pages. So you might want to take a break. We're definitely going to have a couple intermissions in there because it is long-winded, and uh, I'll need a couple drinks of tea in that. 72 pages. I mean, whew, that's a lot to read out loud for anybody. But we'll do her. We'll do her. All right, I'm going to find something for us to look at real quick. All right, all right, all right. Hi, everybody. Welcome. We're going to go ahead now. Keep in mind, this is a cold read. So if I stumble over words, I'm human and I'm sure I'm going to make errors. Let me grab a quick drink here. Yes, audio gone. Oh, yes, the audio was gone, but we're back. We were just taking a minute. You're going to hear my phone dinging here and there. That's just when one of the mods sends me a message so that way I know if I need to stop, if something's went wrong technically, something like that. Sounds good. Thanks, Cobweb. Yep, I'm getting a drink. Thanks. Thanks, Dina. Okay, guys. And with that, here we go. We're starting at 11:35. Let me take a minute to clear my throat. We're looking at, I believe, where is it? 74. Whoop. Let's see. Yeah, 72 pages. Okay. It said one of four up here, and I'm like, it's 72. So this was filed yesterday, actually, for 11/2019, Clerk of Circuit Court, Manitowoc. Let's get rolling. State of Wisconsin plaintiff versus Steve A. Avery, senior defendant. Defendant's motion for leave to file defendant's reply to the state's response in opposition to defendant's motion for retrial. Defendant Steve Avery, by his undersigned attorneys, hereby moves this honorable court for leave to file his reply to the state response to his supplemental 974.06 motion. In support thereof, defendant states as follows. Number one, the causes before this court on remand for the Wisconsin Court of Appeals. 2. The Wisconsin Court of Appeals issued its remand order on February 25th, 2019. In its remand order, the Wisconsin Court of Appeals ordered defendant to file his supplemental post-conviction motion within 14 days. Defendant timely filed his supplemental post-conviction motion in this court on March 11, 2019. Number 4. The Wisconsin Court of Appeals February 25th, 2019 remand order did not authorize the state to respond to defendant's supplemental post-conviction motion. Number 5, without first seeking leave, the state filed an unauthorized and unsolicited response to defendant's post-conviction motion on March 29, 2019. Number 6, defendant now seeks leave to reply to the state's unauthorized and unsolicited response because there are issues and matters of record raised by the state which defendant disputes. Defendant believes the correction of the matters of record will aid this honorable court in resolving defendant's pending supplemental post-conviction motion. If this court denies defendant's motion for leave, this court should strike the state's response because it was unauthorized under the Court of Appeals February 25th, 2019 order. Number 7. A copy of defendant's reply to the state's response is attached here to as Exhibit 1. 8. The request is made in good faith and not for purposes of delay. Wherefore, defendant Steve Avery respectfully requests this honorable court grant leave to reply to the state's response to his supplemental post-conviction motion. And it's respectfully submitted by Kathleen T. Zellner. So before we go any further, let's go over this. Basically, we were waiting on the circuit court to file, and the state has, as we see in this case from the beginning, basically jumped the gun. And Kathleen is saying we did not ask for this response from the state. It's unauthorized, and it's asking us to reply, and we're not in the mood to reply. We want to stay on topic. Now, we're not doing this to slow up the courts, but we want to stay from replying to the state because they're talking out of turn. They don't have the state of Wisconsin does not have the talking stick. So that's what they're asking for. We're asking for a stay so as to not have to reply to the state at this point. So that's the bulk of what she's talking about. And then there's a certificate of service, and it went out to Manitowoc County District Attorney, Assistant Attorney General Thomas J. Fallon, Special Prosecutor Mark Williams, Honorable Judge, I can't say honorable at the same time and read her name, Lynn Zygmunt, and it was signed by Kathleen T. Zellner. So here is the filing 4/11/2019, and it's the State of Wisconsin Plaintiff versus Steve A. Avery. It's the defendant's reply to the state's response in opposition to defendant's motion for new retrial. So what's happened, you guys, is the state is forcing the hand. So in other words, because they've put something on the table, Zellner is replying, but she's asking that we not even have to use this reply or even look at what the state said. Let's stay on topic. Let's stay focused with what the circuit court is doing because they're the ones that have the talking stick. But since the state is talking out of turn, we now need to respond. And in this response, she's saying, weigh this response for me if you're going to consider the states. But if you're not going to consider the state's reply and motion, then just ignore what I'm saying. So this is what if we do have to reply, this is how she replies. Defendant Steve Avery, by his undersigned attorneys, respectfully submits the following reply in support of a supplemental 974.06 motion for post-conviction relief pursuant to the state's violation of Wisconsin Statute 968.205 and Youngblood v. Arizona. The state's procedural bar arguments are themselves barred under the doctrine of judicial estoppel. It is in its February 25th, 2019 order granting Steve Avery, Mr. Avery motion to stay appeal and remand for proceedings in connection with his 968.205 and Youngblood v. Arizona claims, the Wisconsin Court of Appeal expressly stated it desires a ruling on the merits. In contravention to the Court of Appeals directive, the state, in its response, largely ignores the merits of Mr. Avery's claims. Perplexingly, the state has opted to attack Mr. Avery's motion on primarily procedural grounds. Based on the Court of Appeals directive for an adjunction on the merits, Mr. Avery respectfully asks this court to reject the state's procedural arguments. Indeed, the state, in its response, is asking this court to disobey the Court of Appeals order by dispositioning of Mr. Avery's claim based on purported procedural defects. If the state wished to challenge Mr. Avery's claim on the procedural grounds, it should have appealed the Court of Appeals order to the Wisconsin Supreme Court. Instead, the Court of Appeals directive for an adjunction on the merits is properly considered law of the case, and the state's procedural argument should be disposed of as beyond the scope of the remand order. State v. Moek, 2005. The law of this case doctrine is a longstanding rule that a decision on a legal issue must be followed in all subsequent proceedings in the trial court or on a later date. Additionally, the state's procedural bar arguments failed under the doctrine of judicial estoppel because the state previously encouraged Mr. Avery to pursue his claims related to the destroyed bone fragments lest they become procedurally barred. The doctrine of judicial estoppel prevents a party from asserting a position in one legal proceeding that directly contradicts a position taken by that same party in earlier proceedings. See Brandon v. Interfirst Corp. In Wisconsin, judicial estoppel precludes a party from asserting a position in a legal proceeding and then subsequently asserting an inconsistent position. Stop right there. Precludes a party from asserting a position in a legal proceeding and then subsequently asserting an inconsistent position. Didn't that happen with Brendan and Stephen's case? We had the state asserting one position for the Brendan case and a second position for the Avery's case. And one story, if it were true, and it isn't, but if it were, would mean the other one is disproved. So we have inconsistent, and they asserted that. So she might want to use State v. Perry there. All right, and then we're going to continue with the doctrine. The doctrine is equitable in nature, intended to protect the proceedings against odd manipulation. Stop right there. Odd manipulation, Brendan case, Stephen case, and continue. In this case, the state argued in its January 29, 2019 response to Mr. Avery's motion to remand in the Wisconsin Court of Appeals that if Mr. Avery could establish a sufficient reason for failing to raise his claim, he could file a new Wisconsin Statute 974.06 motion, according to the state. Wisconsin Statute 974.06 motion may be made at any time. Wisconsin 974.06, subsection 2, and if the court finds a ground for relief asserted, which for sufficient reason was not asserted in a previous Wisconsin Statute 974.06 motion, the new motion is not subject to the procedural bar of State versus Escalona Navarro. If Avery can establish a sufficient reason for failing to raise this claim in the motions currently under review, the claim will not be barred, and he can file a new Wisconsin Statute 974.06 motion once this appeal has concluded. State's response to motion to remand at 7, emphasis added. Clearly, the state was attempting to induce Mr. Avery to dismiss the pending appeal to pursue his 974.06 claim, thereby, as the Court of Appeals observed, waiving any future review of the orders from which Mr. Avery has appealed. On appeal, the state clearly argued that the only procedural hurdle Mr. Avery needed to jump to bring his destruction of evidence claim was the sufficient reason standard set forth in Escalona Navarra 185, Wisconsin, 1994. Mr. Avery has submitted and renews his submission that the sufficient reason for which he could not raised this claim earlier in the state's concealment of Deputy Hawkins' September 20, 2011 report, and the updated evidence disposition ledgers that reflected the state's return of human bone fragments located in the gravel pit to the Habach family. Notably, the state did not argue that Mr. Avery would be procedurally barred because he had not raised this claim in a motion before the Court of Appeals. Now, the state argues Mr. Avery's claim is procedurally barred, not because he has not articulated a sufficient reason, but for not raising it in his prior 97406 motion, but because he did not raise it in his prior motion before the Court of Appeals. This argument runs directly contrary to the state's prior position. Stop right there. So what she's saying is they claim that the state claims the only reason that he can't do this is because we don't have sufficient reason. Now we've supplied the sufficient reason that we didn't bring it up in the past is because we didn't know about it. It was suppressed, and the court allows that. If you don't have knowledge of it, how could you possibly react? And we continue. This argument runs directly contrary to the state's prior position. Therefore, the state's recent contradictory argument triggers the doctrine of judicial estoppel because it argues a position wholly incompatible with its prior argument. Mr. Avery's claim cannot both be cognizable with a showing why he could not raise it in a prior motion and barred because he did not raise it before the Court of Appeals during the pendency of this court. For this reason, Mr. Avery respectfully asks this court to reject the state's internally inconsistent arguments for the procedural preclusion of Mr. Avery's claim. Notably, the Court of Appeals orders recognizes the duality implicit in the state's argument. Due to this case's extensive history, there is a benefit to having existing claims developed or litigated while they are relatively fresh, rather than positioning the claims to be procedurally barred in the future proceedings. So she's quoting right there what the appellate court has said. The Court of Appeals recognized that this is the proper time and form for Mr. Avery's claims. It would be manifestly erroneous to dismiss them on procedural grounds. However, even the state's procedural arguments fail. For these reasons, Mr. Avery respectfully requests the court grant a supplemental 974.06 motion and order an evidentiary hearing on the I can't even say that word, substantive issues. Sorry about that, guys. The successive supplemental motion is not procedurally barred. The state argues Mr. Avery's claim arising under Youngblood v. Arizona and Wisconsin Statute 968.205 are procedurally barred under State v. Escalona Navarro, 1994. In Escalona Navarro, the Wisconsin Supreme Court interrupted 974 74.06 to procedurally bar a defendant's grounds for relief if they had been finally objected, waived, or not raised in prior post-conviction motion, absent of showing sufficient reason. So stop there. What they're saying is in Escalona, Navarra, the Wisconsin Supreme Court, they stopped the procedure and they barred the defendant for grounds of relief, stating that they were absent of showing sufficient reason why it had not been brought up in the past. We have sufficient reason because the evidence was suppressed. And then we'll continue. In this case, the state first argues Mr. Avery's claims are barred because he failed to raise the issue of retesting the Manitowoc County gravel pit bones in his direct appeal and post-conviction motions. Here, the state misapprehends Miss Avery's claim. In this post-conviction motion, Mr. Avery is not stating a sufficiency of evidence or ineffective assistance of counsel claiming relating to inadequate testing of bone fragments. Rather, Mr. Avery claims pertain to the constitutional violation stemming from the state's destruction of the human bone fragment evidence. The retesting of the bones is relevant to this constitutional claim on the matter of the exculpatory nature of the destroyed evidence. However, the retesting of the bone fragments is not a claim in its own right. Therefore, notwithstanding the Court of Appeals directive to resolve Mr. Avery's claim on the merits, that Mr. Avery did not raise a bone testing issue earlier does not preclude him from raising a constitutional destruction of evidence now. On this point, the state argues that Avery could have raised a claim regarding the destruction of the bone fragments in the Court of Appeals in connection with a prior remand order. The state's argument fails for two reasons. One, it's permissive and factually untrue. Two, even if its premises were true, a prior motion to expand the scope of the remand order is not cognizable as a prior post-conviction motion and contemplated by the Wisconsin Supreme Court in Escalona, Navarro. First, the state's rendition of events is factually inaccurate. Neither Mr. Avery nor his current post-conviction attorneys received Deputy Hawkins' September 20th, 2011 report until after December 17, 2018. The state's I can't even think right now, representation that it mailed the Hawkins report to Mr. Avery's private investigator on May 29, 2018 as part of a complete set of Calumet County Sheriff's Department records or reports is untrue. Indeed, although Mr. Kirby, acting as Mr. Avery's private investigator, remitted payment for the copying and shipping of the Sheriff's Department 1,117-page file. That file was never delivered to Mr. Kirby and therefore was never tendered to post-conviction counsel. It's interesting. I want to stop right there. The KSO is actually 1,116 pages. Interesting. And let's go forward. Specifically, in his affidavit attached and incorporated herein as Exhibit A, Mr. Kirby avers he received one package from the Calumet County Sheriff's Department on May 30th, 2018. Without first opening the package, Mr. Kirby delivered it to the law offices of Kathleen T. Zellner and Associates PC. Mr. Kirby did not see the contents of the package. In addition to paying for the 1,117-page report, Mr. Kirby paid for the copying and shipping of the Sheriff's Department 64-page post-conviction investigation report. Mr. Kirby viewed the Sheriff's Department's May 29, 2018 transmittal letter for the first time after the state attached it as Exhibit 3 to the response to Mr. Avery's supplemental 974.06 motion. Mr. Kirby noted that unlike letters he had received from the Sheriff's Department before, this letter was undersigned by Sheriff Ott and appeared to have been copied from a 3-ring binder. Indeed, the package Mr. Kirby delivered to current post-conviction counsel office did not contain Deputy Hawkins' report or the 1,117-page investigative report the state alleges it delivered. In his affidavit attached and incorporated herein as Exhibit B, current post-conviction counsel law clerk Kurt Kingler avers when he opened the package Mr. Kirby delivered, it contained only the 64-page post-conviction investigation document. Further, the package did not contain the cover letter attached to the state's response as Exhibit 3. Further, the state's contention that current post-conviction counsel acknowledged receiving the investigative reports on or about May 30th, 2018 in Mr. Avery's motion to compel production of recent examination of the DASIC computer filed July 3rd, 2018, misstates the record. Specifically, paragraph 2 of the document states, on May 30th, 2018, current post-conviction counsel investigator James Kirby, pursuant to the Freedom of Information Act, FOIA, received 64 pages of new reports pertaining to a follow-up investigation regarding several allegations or questions raised in several filings of Stephen Avery's current defense attorney, Kathleen Zellner from the Calumet County Sheriff's Department. This statement supports the fact that Mr. Avery received the 64-page post-conviction investigation report. However, the state's argument that indicates Mr. Avery received the 1,117-page complete investigative report or file is a non sequitur. It does not follow that because Mr. Avery received the 64-page report. He have received the 1,117-page report. It says it does not follow that. Okay. Therefore, because the state did not send Mr. Avery's current post-conviction counsel, Deputy Hawkins' report on May 29, 2018, it cannot make the argument that Mr. Avery waived claims related thereto when he did not receive them in his next motion for remand order in the Wisconsin Court of Appeals, because there was no opportunity for Mr. Avery to raise claims related to the doctrine of human bone fragments evidence until after December 17, 2018. Mr. Avery is not procedurally barred from raising them in the instant motion. It bears noting the reason Mr. Avery could not raise the claim related to the destruction of the bone fragments evidence earlier was the state's continued withholding of Deputy Hawkins' September 20, 2011 report. Indeed, the state's attachment of Deputy Hawkins' September 9, 2011 report as Exhibit 2 to its reply constitutes the first and only time it has attended the same to Mr. Avery. All right. Further, even if, arguendo, the state had produced Deputy Hawkins' report on May 29, 2018, then Mr. Avery did not raise claims related to the destruction of bone fragment evidence in his next filing on the Wisconsin Court of Appeals does not preclude him from raising it now. After a diligent review of Wisconsin's jurisprudence, Mr. Avery submits no Wisconsin court order has concluded motions to remand, and by extension, supplemental post-conviction motions limited in scope to the remand order in the Wisconsin Court of Appeals are cognizable as prior post-conviction motions, as contemplated by the Wisconsin Supreme Court in Escalona, Navarro. Stop right there. So she just showed them where Escalona, Navarro actually, again, the state took one little tiny bit of the statement in the Escalona, Navarro motion, and they didn't use it in context. And Zellner's bringing it fully in context here. And they're saying that basically all you need is the reason. That's all that was lacking out of the Escalona, Navarro, is there was no reason why they didn't bring up the motion before. Whereas here, the suppressed evidence obviously means we had no knowledge of it and could not have done it. And we continue. Indeed, the state cites no authority for the proposition that anything but a defendant's failure to raise claims in 1, a prior post-conviction motion in the trial, or 2, their direct appeal serves as a waiver of that claim. See example, State versus Bullock. And that was in 2019. Escalona, Navarro, limited analysis of Escalona, Navarro waiver to claims prior raised in a prior 97406 motion and direct appeal. So right there, she even says it, even on cold read, I got it right. They were limiting the analysis of it. Exactly. They're taking it out of context. All right. And we continue. Therefore, even if the state did tender Deputy Hawkins' September 20, 2011 report to current post-conviction counsel on May 29, 2018, that Mr. Avery did not raise the destruction of evidence claims as a motion to expand the scope of Wisconsin Court of Appeals. Remand order should not bar consideration of it now. Because Mr. Avery's claim could not have been raised earlier, it cannot be barred from Escalona, Navarro. See Stewart versus Martinez, I'll say Villarreal. If a claimant takes the first chance they can to raise a claim, that claim should not be barred by second and successive waiver rules. All right, guys, I'm going to take about a 2-minute break here, catch my breath, get a drink, suck on a cough drop. I've been reading so much, I want to make sure that I don't get a sore throat and I can hear I need a drink. So we're going to give 2 minutes. We'll go back to the chat windows and you can discuss questions you have with the mods, and I will take just a minute. So it's 12 o'clock noon here, 2-minute break. Thank you very much. We'll be right back. All right. Welcome back, everybody. I hope you had a chance to grab yourself a drink, some popcorn, go to the restroom, whatever you needed to do. And with that, let's continue. Zellner is just kicking butt, you guys. This is amazing. She's so incredible. So here we go. Moreover, the state's argument cuts against the Wisconsin Supreme Court's recalibration of the Brady doctrine in Wisconsin versus, ooh, here's a big one, Weyerski. In Weyerski, the Wisconsin Supreme Court corrected the course of Wisconsin's Brady jurisprudence to focus on the state's misconduct instead of the defense's due to diligence. In this case, the state's argument related to the bone fragments returned to the Halbach family smacks of precisely the prosecution practices the Wisconsin Supreme Court condemned in Weyerski. The state has repeatedly concealed and withheld evidence related to the return of the bone fragments. Example, the Deputy Hawkins report and updated evidence disposition logs, and then blamed Mr. Avery for not raising claims related thereto. The state is engaging in a course of conduct proscribed by the United States and Wisconsin Supreme Court's Waskey 2019. A rule thus declaring prosecutor may hide, defendant must seek is not tenable in the system constitutionally bound to accord defendants due process. Stop right there. So, right there, it's stating that you cannot hide the evidence. And, if you don't see it, not my fault kind of game won't work. It's unconstitutional. So, in other words, the system constitutionally bound that you have to be forthcoming in your process as a prosecutor. We don't see that in this case. And we continue. The state should not now be rewarded for engaging in this pattern of conduct. Mr. Avery claims deserves a hearing on its merits. Part 3. Mr. Avery's supplemental motion is properly raised under 974.06. Okay, so she's saying it's not barred, it's actually properly raised, and here's why. In its reply, the state argues that Mr. Avery's Youngblood claim lacks merit because it lacks valid constitutional and jurisdictional basis. The state argument stands on the following premises. 1. A petition under Wisconsin Statute 974.06 is limited to jurisdictional and constitutional issues. And 2. Following DA's Office versus Osborne, 2009, there is no constitutional due process right to the preservation of forensic evidence. For the following reason, both premises fail. Without legs, the state's argument cannot stand. First, the state's argument, 974.06, applies only to just jurisdictional and constitutional claims. In support, therefore, the state cites State versus Belliette, 2011, and State versus Nickel, 2010. Belliette, for its part, borrows the relevant language from State versus Allen, 2010, which in turn paraphrases Wisconsin Statute 974.06. Thus, the Balliet reasoning on the scope of 974.06 jurisdictionally or jurisdiction is rooted in the statutory language itself. As for Nickel, the Court of Appeals comment that a 974.06 motion is limited to constitutional and jurisdictional challenges, 2010, is indicata and made without reference to any authority. In any case, Mr. Avery respectfully submits Nickel mistakes the law. Indeed, this court should look at the scope provision that Wisconsin legislature wrote in 974.06. In relevant part, 974.06 states as follows. Stop right there. Here she's going to put it in context. And we continue. After the time for appeal or post-conviction remedy has expired, a person in custody under sentence of court, claiming the right to be released upon the ground that the sentence was imposed in violation of the U.S. Constitution or the Constitution or the laws of the state, may move the court which imposed the sentence to vacate, set aside, or correct the sentence. Right there it is. She nailed it. Emphasis added. Clearly, claims arising under Wisconsin statutes are cognizable under 974.06. Regardless, Mr. Avery's Youngblood claim related to the destruction of human bones from the Manitowoc County gravel pit is cognizable under 974.06 because it is constitutional in nature. On this point, the state argues Youngblood and its progeny do not apply to post-conviction proceedings. Here, the state's arguments wholly ignores the state of the law. In Wisconsin, post-conviction defendants have a due process liberty interest in the post-trial destruction of evidence. State versus Parker, 2002. There is a long line of cases addressing the pretrial destruction of evidence and the defendant's due process rights. We see no reason why this line of cases should not apply to post-conviction challenge to a post-conviction destruction of evidence. The Parker Court adopted to the due process destruction of evidence set forth in State versus Noble 2001. Noble, in turn, reiterates the destruction of evidence due process test in State versus Greenwald 1994. Greenwald, the defendant's due process rights are violated by the destruction of evidence if 1. The evidence destroyed is apparently exculpatory and of such a nature that the defendant would be unable to obtain comparable evidence by other reasonable available means. And 2, if evidence was potentially exculpatory and was destroyed in bad faith. Noble 2001. Thus, there is a cognizable due process right. Due process right, yes, to the preservation of evidence post conviction. Wisconsin courts have recognized the constitutional dimension of the state's failure to preserve potentially exculpatory DNA evidence. Here, the state violated Mr. Avery's due process right to the post conviction preservation of potentially exculpatory evidence. As previously stated and in line with the Court of Appeals directive, this claim deserves to be heard on its merits. It is important to note that Osborne involved a civil rights claim under 42 U.S.C. 1983, asserting a federal constitutional due process right to access evidence for DNA testing. Osborne, 557 U.S. at 52. It was into this context, the Supreme Court held the post conviction preservation of DNA evidence is not protected due process right. Indeed, the Supreme Court constitutionally criticized Osborne for failing to request the sought after evidence in state court. His attempt to sidestep state process through a new federal lawsuit puts Osborne in a very awkward position. It is difficult to criticize the state's procedural when Osborne has not evoked them. It is Osborne's burden to demonstrate the inadequacy of the state law procedure available to him in the state post conviction relief. These procedures are adequate on their faces. Sorry, my phone was ringing. Adequate on their face and without trying them. Osborne can hardly complain that they do not work in practice. Thus, Osborne is, in application, more a case about waiver of state law post conviction remedies than it is a blanket proscription of any due process rights after conviction. Mr. Avery, not wanting to stand in Osborne's shoes, now marshals state law post conviction remedies, including remedies related to the destruction of apparently exculpatory or potentially exculpatory human bone evidence from the Manitowoc County gravel pit. In doing so, Mr. Avery relies upon the due process right to post conviction preservation of evidence conferred in Parker. So stop right there. She's saying that we don't want to end up in Osborne's shoes, where in that case, he just was negligent and didn't bring it up. So we're trying to follow suit and bring it up when it's brought to us immediately, which was as soon as we got Deputy Hawkins' report. So rather than stand in Osborne's shoes, she's about to quote a new way to do that. So let's see, where were we? I lost my place in doing so. Mr. Avery responds, Parker. This reliance is not at odds with Osborne, rather. It is the exercise of Osborne's broadest holding. The state should retain the authority to extend due process liberty interests to a criminal defendant after conviction. There you go. If we extended substantive due process to this area, we would cast state remedies in constitutional doubt. Because 974.06 expressly contemplates claims arising under Wisconsin statutes, and because post conviction destruction of evidence claims are cognizable due process claims in Wisconsin, Mr. Avery has stated a cognizable claim for relief under 974.06. So, cognizable means that it's thought out, it's well delivered, and we have good merit, good reason. So, part 4. Let's take a little drink here. Gotta keep the duckbill wet here. Mr. Avery, having stated a cognizable claim for relief under 974.06, has met his pleading burden. The state next argues that Mr. Avery has not sufficiently pled his post-conviction destruction of evidence claim because the bone fragment evidence is, according to state, neither apparently nor potentially exculpatory. State response is quoted there. Here, the state makes a fatal error in its argument. It conflates Mr. Avery's burden to show that the testing of the destroyed bone fragments was exculpatory. Either one, apparently exculpatory, or two, potentially exculpatory, and the destruction was made in bad faith, with the burden Mr. Avery would face where he makes a claim of third party liability under State versus Denny. The state is plainly mistaking Mr. Avery's argument. Mr. Avery's destruction of evidence claim is not a third party liability claim. Indeed, nowhere is a burden to show the identity of the true perpetrator imposed upon Mr. Avery. Mr. Avery need only marshal evidence demonstrating the testing of now destroyed evidence was one, apparently exculpatory, and two, potentially exculpatory, and the destruction was made in bad faith. Exculpatory evidence is evidence that suppression of which would undermine confidence in the verdict. Okay, stop right there, you guys. Confidence in the verdict. So what that means is, um, and I'm sure you've heard Eric Cozy talk about this a lot, and he's very right. In other words, the jury may have decided differently had they been aware of the evidence. We have suppression of the evidence, the Bobby Dassey tapes. We also have suppression of the evidence by the destruction in itself of the bones. So we definitely have obviously, if you knew all the story, you're going to make a different decision than if somebody comes in. And the state of Wisconsin likes to take things out of context. And they did that in this case. And we continue with our 72-page document. Thus, Mr. Avery's burden is to explain why this evidence undermines confidence in the verdict, not prove someone else's guilt. The state is arguing that it is Mr. Avery's burden not only to present substantial evidence in support of his innocence, but also show that someone else perpetrated the crime of his conviction. These burdens are far from the same. By way of analogy, the state's argument is akin to requiring a criminal defendant convicted on dispute DNA evidence to show not that the DNA excludes them, but prove whose DNA it really is. Such a burden cannot be imposed here. In subsection I, she makes this point. The destroyed bone evidence was apparently exculpatory or potentially exculpatory. Next, the state argues, in the context of its misguided Denny third party liability argument, that the bone fragments were neither apparently nor potentially exculpatory. Additionally, the state argues there are many fragments from the quarry that may or may not be human still in evidence available for testing. The state argument misses the point. Mr. Avery's claim concerns the testing of human bone fragments from the gravel pit to adduce their identity and demonstrate that the evidence was not, as the state argued at trial, concentrated in Mr. Avery, such that he was the sole subject. Indeed, Mr. Avery's claim concerns destroyed bone fragments identified as human by Dr. Leslie Eisenberg. These bones are listed in Exhibit 10, Mr. Avery's supplemental motion. The skeletal remains contained in this table that can be reliably traced to the gravel pits are Wisconsin Crime Lab, and then she lists out the bones. 9411, 9412, 9413, 9414, 9416, 9419, and followed by question mark 8675. Without exception, every one of these items was returned to the Halbach family. There's no comparable evidence now available to Mr. Avery for testing because there are no human skeleton remains recovered from the gravel pit preserved in state custody. The state limits its arguments to Wisconsin State Crime Lab number 8675, the pelvic bone fragment Dr. Eisenberg classified as possible human, and which Dr. Stephen Symes has, based upon his examination of the forensic anthropology photographs, confirmed were human. This choice is perplexing because Mr. Avery's claim concerns all human bone fragments recovered from the Manitowoc County gravel pit, then returned to the Halbach family in September 2011. Dr. Eisenberg, without qualification or equivocation, identified as human Wisconsin Crime Lab number 7411, 7412, 7413, 7414, 7416, and 7419, Exhibit 10 to Mr. Avery's supplemental motion doctrine 1031 at 8. For the state to now argue that Mr. Avery's claim fails because he has made no showing that the bones were human in I can't even say it, is disingenuous and mistakes Mr. Avery's argument. First, the state's argument is disingenuous because it is beyond argument that Wisconsin crime lab number, those numbers were human in origin. It is past time for the state to credit the conclusions of its own experts. Second, evidence of the identification, as opposed to the species of the bones, tends to prove Mr. Avery was not the perpetrator of Mrs. Halbach's murder. Because if the bones were identified in Mrs. Halbach, her murder, mutilation, and the disposal of her remains did not occur in the location tied exclusively to Mr. Avery. No reasonable trier of fact could conclude that if Mr. Avery murdered and mutilated Miss Halbach in the Manitowoc County gravel pit, he would move her bones to the gravel pit to his own burn pit and thereby incriminate himself. This evidence should be considered in light of the opinions of Dr. D. Hain, who, to a reasonable degree of certainty in the field of fire forensics, has concluded Mr. Avery's burn pit was not the primary burn location. Thus, it is reasonable to conclude the gravel pit was the primary burn site. This evidence, therefore, tends to show the murder, mutilation, and destruction of Miss Halbach's remains did not occur, as the state argued at trial, in locations controlled exclusively by Mr. Avery. This evidence is exculpatory of Mr. Avery because it undermines confidence in the verdict. In the words of one Mr. Avery's trial attorney, Jerome Buting, and I quote, "If that body was burned somewhere and then moved and dumped on Mr. Avery's burn pit, then Stephen Avery is not guilty, plain and simple. Now that is why the state has gone to such trouble avoiding the fact that the bones were moved. That's why you heard nothing about it here, because it does not fit with their theory that Avery is guilty." While the jury at Mr. Avery's trial rejected Buting's argument, it did not have the benefit of hearing evidence that the bone fragments later returned to the Halbach family were originally located in the Manitowoc County gravel pit and were unwaveringly identified by Dr. Eisenberg as human. This, coupled with the other incriminating evidence linking the Manitowoc County gravel pit to the crime scene, see Mr. Avery's March 11, 2009 supplemental 974 motion, Doctrine 1000, significantly undermines confidence in Mr. Avery's verdict because no reasonable trier of fact could have concluded, considering the significant evidence pointed away from Mr. Avery, that Mr. Avery is guilty beyond a reasonable doubt. The state makes much of the Dassey burn barrel and its theory that Mr. Avery placed the bones in the gravel pit to evade direction. This theory ignores Dr. D. Hain's scientific opinion that Mrs. Halbach was not burned in Mr. Avery's pit. As previously stated, the notion that Mr. Avery would burn Miss Halbach's body at the same location other than his burn pit, then transfer her remains to the defies logic. Because it is logically unsound and because it stands against the weight of Dr. D. Hain's opinions, the state theory should be rejected. For these reasons, Mr. Avery has sufficiently pled the apparent and potential exculpatory value of the destroyed bone evidence. Subsection II. The bones were destroyed in bad faith. Next, the state argues that it did not act in bad faith when it released the bone fragments to the Halbach family. In support thereof, the state argues that it undertook reasonable efforts to test Wisconsin State Crime Lab number 8675 before Mr. Avery's trial, and that it was justified in destroying the bones because there were not an issue with Mr. Avery's direct appeal. Let's stop right there. Yeah, it is, because you have to have permission from everyone. You have to have all the lawyers, you have to have the defendant, and you have to have everyone on board with a signature on the dotted line that says, yeah, you can destroy these. That is part of that law. So I'm sure that's where she's headed, and let's continue. So in arguing, the state wholly ignores the trial court's April 4th, 2007 DNA evidence preservation order and the duty to preserve evidence imposed by 968.205. As for the April 4th, 2007 preservation order, stop right there, preservation order. So in April 4th, 2007, the preservation order told them to preserve the evidence for future testing. Okay, back on track. The state was on notice that the forensic evidence collected in the case should be preserved for future testing by Mr. Avery at any time. That the order expressly contemplates only blood evidence is not dispositive. The parties have construed the order to cover the testing of skeletal remains, a bullet fragment, and a swab taken from the RAV4 hood latch. It should also be understood to cover human skeletal remains from the gravel pit. Further, the state demonstrated its awareness of Wisconsin Forensic Evidence Preservation Statute 968.205 at trial. Special Prosecutor Gahn noted, quote, let's wait to arrange the preservation of evidence until these proceedings are over, because Wisconsin does have a mandatory preservation statute that would be applicable in this case. Mr. Avery submits this recognition confirms his contention that the state knowingly violated the preservation statute when it returned human skeletal remains from the gravel pit to the Halbach family in September 2011. That is, the state knew it had a duty to preserve the evidence or prior to destroying it, notify Mr. Avery and his attorneys. Yet it did neither. This knowingly deviation from its duty under the law confirms the state acted in bad faith when it destroyed the human bones from the gravel pit. It bears noting that Assistant Attorney General Fallon and Special Prosecutor Gahn, both of whom represent the state in this proceeding, were the state's attorneys who participated in the return of the human bones from the gravel pit to the Halbach family. They are interested parties, and their bad faith is directly an issue in this case. Their protestation and denials are therefore suspect. This case must discern whether their arguments themselves are made in good faith or in simply interest of self-preservation. Given the manifest weight of the evidence and the arguments offered by the state, Mr. Avery suspects the latter is true. After all, the upshot of Mr. Fallon and Mr. Gahn's arguments is that they reawakened the Halbach family's grief in 2011 to give them animal bones. Oh, let's stop right there. That is the most favorite line I've ever read. After all, the upshot of Mr. Fallon and Mr. Gunn's arguments is that they reawakened the Halbach family's grief in 2011 to give them animal bones. We've got to screenshot that. We're doing a tweet after this. Oh my golly, that's the best thing. I love the word upshot there, you guys. It's just great. Right there. So all this talk the state has done about not upsetting the Halbachs, she nails it right here. So we're going to save this. We'll throw it in the library. Um, let's see here. Let's go to OneDrive, and we'll tweet this later. We're going to put it right in the post conviction file there. So it'll take me just a minute because I got this stuff. Like, yeah, this case is huge. So how do we want to do this? We put it right with the state claims fair trial. So upshot, okay. Reawakened. That's what we'll call it. Reawakened. Halbach families grief to give them animal bones. And bam. We will be tweeting that. We may have to make a shirt on that. Okay, you guys. If I can get the screenshot to end, it's saving it. So let's take a minute. Let's go ahead. It's been almost a half hour, and this is a very long document. Let's go ahead and take a 2-minute break. We can join the chat and see how everybody is doing there. Okay, guys, 2-minute break. We'll come back a little bit right after 12:30. All right, guys, welcome back. So I'll let you get situated. I have a little bit of a cold kind of coming on me, so, uh, you know. All right, here we go, guys. We are going to back up because I did see that Jimmy had said he did not see that last little bit. And it says right here, after all, the upshot of Mr. Fallon and Mr. Gahn's arguments is that they reawakened the Hallbox family's grief in 2011 to give them animal bones. That's pretty hard hitting. All right. Further, Mr. Avery has alleged sufficient material facts in support of his destruction of evidence claimed to secure a post conviction hearing. State v. Allen, 2004. As for who, Mr. Avery has alleged Investigator Wiegert, Deputy Hawkins, Assistant Attorney General Fallon, and Special Prosecutor Gahn destroyed every human bone recovered from the gravel pit by returning them to the Halbach family. As for what, Mr. Avery has alleged the bones were identified as human by Dr. Eisenberg and were recovered from multiple locations in the Manitowoc County gravel pit. As for where, Mr. Avery has provided this court with the exact locations of the human bones recovered in the Manitowoc County gravel pit. As for when, Mr. Avery has alleged the human bones from the gravel pit were returned to the Halbach family on or after September 20th, 2011, during the pendency of his direct appeal. As for why, Mr. Avery has alleged he is entitled to relief on his claim because the state violated his due process rights, extended to post conviction proceedings in Parker to the preservation of apparently or materially exculpatory evidence, and the state acted in bad faith in doing so. As for how, Mr. Avery has alleged, okay, you guys, that looks French, but I'll try it. It could be Latin, most likely. Injuria alia, I may have said that wrong, facts supporting his contentions that the destroyed bone evidence was in fact exculpatory, and the state acted in bad faith in destroying them. Each of these facts substantiates Mr. Avery's destroyed evidence claim. Because of each of these facts has been sufficiently pled, Mr. Avery has stated a cognizable claim for relief under the framework of Trombetta and Youngblood. And Part 5. The state violated Wisconsin Statute 968.205. The state argues that the human bone fragments from the gravel pit were not subject to preservation under Wisconsin Statute 968.205. The state correctly notes that 968.205, subsection 2, protects biological material from the victim, or that may reasonably be used to incriminate or exculpate any person for the offense. However, the state makes its first misstep when it equates the evidentiary value of the human bones located in Mr. Avery's burn pit or the Dassey burn barrel with human bones located in the Manitowoc County gravel pit. The location from where the human bones were recovered is key to their evidentiary value. Additionally, the state never ascertained the identity of any of the human bones from the gravel pit. Now, by the state's actions, their identity may never be ascertained. Thus, no comparable evidentiary material is available to Mr. Avery. Additionally, Mr. Avery is not positioning, or no, depositing, posting, I don't even know how to say that, po- posting 968.205, somebody help me with that word, should be interpreted as a mandate to preserve every single piece of biological evidence recovered during the investigation. Indeed, Mr. Avery is simply posting the state should comply with Wisconsin law when considering the preservation of evidence that may reasonably be used to exculpate someone. In this case, as described herein and in Mr. Avery's March 11, 2019 supplemental 974.06 motion, the human bones recovered from the gravel pit may reasonably be used to exculpate Mr. Avery because they undermine confidence in the verdict, and the evidence, if tested, could reasonably prove Mr. Avery's innocence. Here again, the state contends none of the bone fragments recovered from locations in the quarry were positively identified as human. Thus, allegation is patently untrue. Without qualification or equivocation, Dr. Eisenberg, the state's own expert identified as human, Wisconsin Crime Lab 97411 7412, 7413, 7414, 7416, and 7419. The state has a statutory obligation to preserve the evidence because the human bones from the gravel pit, if determined to be Miss Halbach's, would prove Mr. Avery innocent. As described herein, proof that Mrs. Halbach was murdered or mutilated in an area outside Mr. Avery's control proves his defense that her remains were planted in his burn pit and therefore he is innocent. His innocence. Thus, even if the human bones from the gravel pit were not subject to 968.205 preservation because they were identified as Miss Halbach, they were subject to 968.205 preservation because they were reasonably likely to exculpate Mr. Avery. Section 6. The state's argument relies on state sources and misrepresents the validity or the validated and accepted capabilities of Andy Rapid DNA identification technology. Yeah, the state doesn't even understand it. They're arguing the guy that wrote it, the guy that made it and invented it. That shows intelligence there. Excuse me. Lastly, the state argues that because rapid DNA technology is not authorized or approved for forensic use, the state should not entertain Mr. Avery's argument that anti-rapid DNA identification analysis could be used to a reasonable degree of certainty, yielding probative evidence of the identity of the gravel pit bones. In support thereof, the state contends such a forensic application is beyond the scope of the Rapid DNA Act of 2017. The state relies on stale standards and inapposite policy positions. Specifically, the state conflates the scope of the Rapid DNA Act with the universe of applications in which anti-rapid DNA technology has been successfully used. This argument is fallacious and reductive. It wholly discounts the development, validation, and widespread acceptance achieved by the ANDI system in forensic applications in recent years. The successful iteration of the Rapid DNA Act was introduced by United States Representative Jim Sensenbrenner on January 12, 2017. It is notable that the language of the Rapid DNA Act did not change from its first introduction in the House on January 13, 2005. That is, the 2017 Rapid DNA Act is composed of language that reflects the state of rapid DNA technology in January 2015. For its part, the 2017 Rapid DNA Act was enacted to authorize law enforcement agencies to use rapid DNA instruments to test arrestees upon booking a police station to screen them for connection to other crimes before being released. Thus, the Act did not contemplate the universe of forensic application for which rapid DNA analysis has been proven suitable in the 4 years since initial introduction. Moreover, the language of state claims is specifically stated in the Act is, in fact, not contained in the Act. The quoted text, present, rapid DNA technology can only be used for identification purposes, not crime scene analysis, comes from the House Judiciary Committee May 11, 2017 report. First, this quote is a simple statement of the focus of the Act. To identify suspects in some way, fingerprint is used. It should not be read as a definitive delimitation of the usefulness of rapid DNA technology. Second, this part, like all the persuasive authority marshaled by the state, is fatally outdated. It states the capabilities of the technology before May 2017. The capabilities of rapid DNA technology have developed considerably since May 2017, as described in Richard Selden's second supplemental affidavit attached and incorporated herein as Exhibit C, anti-rapid DNA identification. We're going to stop there and we're going to read the side note. Let's see, just scan it. Indeed, the most recent publication cited by the state is a National District Attorneys Association position statement on the use of rapid DNA technology dated January 30th, 2018. So the state went and grabbed an outdated form rather than checking the 2018 one. The statement reads, oh, it's so tiny. In relevant part, NDAA does not support the use of rapid DNA technology for crime scene DNA samples unless the samples are analyzed by expert experienced DNA analysis using the technology working in an accredited DNA laboratory. Just what I said before in the last motion. This position, recognized over 1 year ago, comports with defendant's position, not the state's. Rapid DNA technology is suitable for the analysis of crime scene DNA samples when the samples are analyzed by experienced DNA analysis and are in an accredited DNA laboratory. So let's back up and grab that last sentence so we get it in context. Sorry about that. As described in Dr. Richard Selden's second supplemental affidavit, anti-rapid DNA identification technology has garnered widespread validation and acceptance in jurisdictions across the country for the analysis of crime scene samples. Specifically, the American Society of Crime Lab Directors, the ASCLD, whose November 15, 2017 position paper the state cited, has recognized rapid DNA's usefulness in the field of disaster victim identification. Disaster victim identification using rapid DNA technology involves the analysis of degraded samples, far more complex than the single source identification samples referenced by the state. Clearly, the ASCLD's interest in rapid DNA technology, forensic samples, has evolved considerably significant technology developments over the past several years. Additionally, rapid DNA technology has been implemented in jurisdictions across the country to process forensic samples. On April 10, 2019, Kentucky Governor Matt Bevin announced that after months of careful consideration, his Commonwealth is using the anti rapid DNA identification system in sexual assault investigations. As described by Dr. Selden, sexual assault evidence kits, SEEKs, contains among the most difficult forensic samples vaginal swabs that contain a mixture of female epithelial cells and male sperm cells. These complex forensic samples can be processed on the ANDI system. In fall 2018, the Utah Attorney General announced that Utah has implemented the ANDI Rapid DNA system for the processing of forensic and crime scene samples. Indeed, Attorney General Sean Reyes announced rapid DNA technology solved its first case within a week of its implementation. In that case, blood and other forensic samples were processed to identify a burglar. On February 11, 2019, the Office of the New York Chief Medical Examiner presented its work using the ANDI Rapid DNA identification system to the American Academy of Forensic Sciences. The Chief Medical Examiner's Office reported its conclusion that rapid DNA analysis of bone samples was comparable to conventional laboratory methods and described two cases where the ANDI system was superior to conventional methods. The ANDI system generated DNA identifications from skeletal remains from the September 11, 2001 World Trade Center tragedy, which yielded no useful results when analyzed using conventional methods. That's quite interesting. Hmm. Okay. Lastly, the Sacramento County coroner recently published a paper describing her experience with the lauding the useful of anti-rapid DNA technology. Using anti-rapid DNA technology to identify victims in the campfire, the coroner successfully identified no less than 85% of the human remains from the campfire. Thus, accomplishment is notable because many of these bone samples were severely degraded by fire, just as the skeletal remains recovered from the Manitowoc County gravel pit were. Thus, the successful implementation of the anti-rapid DNA technology in the aftermath of the 2018 California wildfires directly supports the applicability of anti-rapid DNA technology in this case. The state's conclusion that rapid DNA testing is not ready for crime scenes relies on stale sources and is ignorant of that technology's development in recent years. While there is a huge difference between fresh buccal samples and a 14-year-old charred calcined bone fragments, as the state quoted you guys, anti-rapid DNA technology is equipped to process 14-year-old charred and calcined bone fragments. That the state has chosen to ignore the multitude and supporting examples referenced by Dr. Selden and instead selectively relying on outdated policy statements does not change this fact. Conclusion. For the above stated reasons, Mr. Avery requests this court grant his supplemental 974.06 motion, set his cause for new trial, reverse his conviction, or grant any other relief this court deems appropriate. Dated April 11, 2019, Kathleen T. Zellner. So you guys, wow. We've got the affidavit attached of James Kirby we went over last time. And you can see here he paid for it. And let's just dig in a little bit. He paid $279.29 for a complete investigative report. And it says, which consists of 63 pages. I have a total here. So right here, where is he getting 1,117 pages? It says right here, he is signing, Dear Mr. Kirby. I mean, this is coming right from Mark R. O. Sheriff. Okay, Chilton, Wisconsin. Dear Mr. Kirby, in receipt of your payment totaling $279.29, we have prepared a copy of the complete investigative report. The Calumet County Sheriff's Department will also release the post-conviction, which could, oh, so there is something else. Let's go back up. So he got that. I was just wondering what else he got. So because it says in addition, at least okay. I paid the copy fee, the sheriff department. Okay, we're backing up, guys. Here it is. The sheriff's department informed me that it would provide the complete investigative report consisting of 1,170 pages for a copy fee of that price, $279.25 plus shipping costs. I paid the copy fee. The sheriff's department contacted me again on May 18, 2018, informing me it would also release a 63 page. So what Zellner's saying is when they opened that file, so Kirby got it, didn't open it, handed it to Zellner, she opens it. All it had was a 63 page report. And because they said it was a completed copy, well, they assumed that that was a completed copy. So more of the Kirby purchase of those documents. And then this is affidavit of Kurt Klinger, or Kingler, I should say. And this is part of the attachments that she's got. It is not part of her motion in the sense of what she's saying, but it is an attachment to her motion. And this is Kurt Klinger. And he's saying that he did deliver to Mrs. Zellner one package from I opened. Okay, this is the guy that opened the package from James Kirby. So here we go. We're going to jump right in here. So on May 30th, 2018, James Kirby delivered to Miss Zellner's office one package from Calumet County Sheriff's Department. I opened the package to examine its contents. Inside the package were 64 pages of a Calumet County Sheriff's Department investigative reports with dates ranging from August 30th, 2017 to April 5th, 2018. There was no cover letter in the package. I scanned the 64 pages of the investigative reports and filed them. And that's his affidavit. And it has a notary republic showing that it is a legal document. State of Wisconsin, this is their claim. Now comes your affidavit, Richard F. Selden. And we read this last time as well. And this is stating that the state cherry picks outdated. Oh, actually, let's read this. I don't think we did read this. Let's go up and see. Oh, this was filed too. Let's continue to read this one. This is a second supplemental affidavit of Richard F. Selden, MD, PhD. Let's take just a 2-minute break before we start this. It's going to explain to us which this forensic specialist that created the Andy system is going to give an affidavit on why the state is incorrect on what the Andy system is capable of doing. So we'll come back to chat real quick. And I'm going to mute my mic for just about 2 minutes, and then we will continue. All right, you guys, and welcome back. Let's get started with this. So we have State of Wisconsin plaintiff versus Stephen Avery Sr., second supplemental affidavit of Richard F. Selden, MD, PhD. Now comes your affidavit. Richard F. Selden, MD, PhD, and under oath hereby states as follows. 1. I am of legal majority and can truthfully and competently testify to the matters contained. Ooh, this is really blurry, you guys. Ooh, what did I just do? Made it too big. We're going to bring it up. I hope it's not too blurry, but the actual paperwork, the copy I got is very blurry. I'm not sure why. So it's not your computer, it's not mine, it's the paperwork. Number 1, I am of legal majority and can truthfully and competently testify to the matters contained herein based upon my personal knowledge and to a reasonable degree of scientific certainty. The factual statements herein are true and correct to the best of my knowledge, information, and belief. Number 2, I obtained my MD from Harvard Medical School in 1989 and my PhD in genetics from Harvard Graduate School of Arts and Science in 1986. In 2004, I founded Andy, a developer and manufacturer of rapid DNA technologies. I've served as director of Andy since 2004 and was its chief executive officer from 2004 October 2016. Since October 2016, I've served as chief scientific officer for Andy. A copy of my CV is attached and incorporated herein as Exhibit 1. Number 3, I've reviewed the state's response to Mr. Avery's motion for new trial based on alleged young blood violations and offered the following opinions in response. 4, the state's assertion that Andy rapid DNA identification technology is not authorized or approved for forensic use is demonstrably incorrect. The state cherry picks outdated and incomplete information, relying primarily on the Federal Rapid DNA Act of 2017 as proof that the Andy Rapid DNA identification system is not authorized or approved for forensic use. This reliance is ill placed, and I will explain the state's errors in this regard, update the incorrect statements of the response, and expand the cherry picking to provide a more complete view of the current widespread use of rapid DNA in forensic applications. Number 5, introduced by Representative Jim Sensenbrenner. The goal of the Federal Rapid DNA Act of 2017 was to allow police officers to use rapid DNA instruments to test arrestees at the police station, allowing them to be linked to unsolved crimes before being released. The Rapid DNA Act of 2017 and this application are based on the rapid DNA processing of buccal cheek swabs from arrestees. The topic of rapid DNA processing of crime scene samples was not contemplated in the Act as it is focused on arrestee testing. Number 6, as opposed to the suggestion of the state, the Rapid DNA Act simply does not contain any language that states that at present rapid DNA technology can only be used for identification purpose, not crime scene analysis. Rapid DNA Act 2017. This quote is not from the law, but instead from a House report, a statement that simply makes clear that the focus of the law in the testing of the arrestee samples. Number 7, the fact that a groundbreaking federal law allows rapid DNA testing of arrestees in police stations across the country cannot be interpreted to mean that the Andy Rapid DNA identification technology is not authorized or approved for forensic use. Before dealing with specific authorizations and approval, I'd like to update events since 2017 House report and related positions statements. Number 8, having performed you all man work on rapid DNA testing of buccal swabs, the FBI is now working on developing guidelines for rapid DNA testing of forensic samples. Specifically, Andy Corporation has now worked with the FBI on a variety of forensic samples, including bone, and the FBI has formed a crime scene rapid DNA task force. I had the honor of presenting to that task force 3 weeks ago, and the FBI has clearly stated in public meetings their interest in rapid DNA of forensic samples. This interest makes perfect sense. The Rapid DNA Act was introduced in 2015, and rapid DNA technologies has advanced dramatically over the past 4 years. Number 9, similarly, the American Society Crime Lab Directors, ASCLD, has also taken note of technology advanced in rapid DNA processing of forensic samples, and particularly in rapid DNA processing of degraded samples such as those found following mass casualty events. Next month at our national meeting, ASCLD will be hosting a full day disaster victim identification workshop conducted by ASCLD's DVI Rapid DNA Subcommittee in partnership with the Department of Homeland Security Science and Technology Directorate and the National Institute of Justice Forensic Technology Center of Excellence. The rationale for the workshop is since crime laboratories are often the DNA experts for the state and local government, it is important that the forensic laboratories are prepared for mass fatality DNA response. Rapid DNA is becoming an important tool in DVI operations, and the workshop is designed to give laboratory directors and supervisors the opportunity to experience how rapid DNA instruments are used in identification efforts during a mass fatality response. Once again, it makes sense that the ASCLD's interest in rapid DNA technology for forensic sample is evolving based on significant technology developments over the past several years. 10. But let's move beyond groups that are now becoming interested in rapid DNA processing of forensic samples and turn to agencies that are successfully using technology today. 11. On April 10th, 2019, the governor of Kentucky announced that following months of careful evaluation, the Commonwealth is using the Andy Rapid DNA identification system for sexual assault investigations. Sexual assault evidence kits, SEEKs, contain among the most difficult of forensic samples vaginal swabs that contain a mixture of female vaginal epithelia cells and male sperm cells. Epithelia, I think that just means skin. Sorry, I had to put the kitty out. She was climbing all over the keyboard. These complex forensic samples can be processed on the Andy system. Governor Matt Bevin stated, we have taken a bold step in order to reduce the incidence of this heinous crime. We have evaluated powerful new technology, rapid DNA, and determined that it can be helpful, that it can help us to identify an assailant in a matter of hours, allowing us to focus the investigation of sexual crimes more quickly than ever before. Number 12. In fall 2018, the Utah Attorney General announced that the state of Utah has implemented the Andy Rapid DNA identification system for the process of forensic samples. Following 2 months of evaluation, Attorney General Sean Reyes announced the first cases was solved 1 week of the technology released. In particular, excuse me, a burglary was solved by using the Andy system to test blood and other forensic samples. The Attorney General included a video describing the use of the technology in a November 2014 press release. 13. On February 11, 2019, at the American Academy of Forensic Science and the New York State Office of the Chief Medical Examiner presented their work on the Andy Rapid DNA identification system. They concluded that rapid DNA processing of bone was comparable to conventional laboratory methods. In fact, they reported 2 cases in which the Andy system generated DNA IDs on bones from 9/11 World Trade Center samples that had given no useful results using conventional methods. I want to jump up. I want to catch this. Um, okay, so there are some source material for you in that footnote that is very good, and you might want to look up. That's how we do a lot of our research is source notes. And we're moving on to 14. In my previous affidavit, I discussed the success of the Andy Rapid DNA identification system in generating identifications following the November 2018 Camp Fire, the deadliest wildfire in California history. In March 2019, the Sacramento County Coroner Kim Jen published a paper on her experiences running the identification effort. And we quote, from the very beginning of accepting the request for aid, I had dreaded having to wait months or years to receive identifications on the fire victims. Instead, in the first week, we began making DNA based identifications. 3 months later, 87% of the families touched by this horrendous event had closure instead of being told they had to be patient and wait longer for testing to be completed and the death certificate issued. When your loved one is missing and may be deceased, telling someone to wait patiently is akin to torture. Andy had shortened the time for the DNA testing, and in doing so, changed the way we now look at mass fatality identification. As a coroner, I cannot imagine handling any future incident, one that obliterates human identity as did the campfire, without using rapid DNA technology. 15. Also, in my previous affidavit, I list a number of U.S. and international agencies that are using the ANDI system for forensic sampling. Without going through each of them in detail, as in the above four application, it is clear that the ANDI system is well suited for the analysis of forensic samples in general and the bone fragments of the instant case in particular. I will not reiterate my grave reservations about the destruction of probative value resulting from the transfer of certain evidence in this case, as that was also covered in my previous affidavit. 16. In conclusion, the state's claim that simply stated, oh, let's check a Discord message in case it's one of the mods. You just never know. Okay. There are some in there in chat. If you do care to be in there as well as in here, you can do both. All right. Many agencies have approved the use of the system for the crime scene analysis of forensic samples and are having spectacular success. The state's cherry picking of older FBI statements is an apposite. The state's claim that experts in the field have determined that rapid DNA is not ready for crime scene is also incorrect. Misleading extracts from earlier FBI policy statements do not change the fact that technology advances over the past several years have rendered the state's position inaccurate and stale. But I can't agree with one of the state's position. It is certainly true that there is a huge difference between fresh buccal swabs and 14-year-old charred and calcined bone fragments. There are several huge differences. I have studied those differences, and based on my personal experience and those of others, it is clear the anti-rapid DNA identification system is well suited for the analysis of the fragments in question. And he signs that, and it's an affidavit. Richard F. Selden, I personally thank you, sir. Please stay with us, and we appreciate you so much. Okay, let's go to the okay, this is his actual like bio, and I'll let you guys go through that. You can see it's very extensive. He is our DNA guy. He is a big DNA guy. And if you're on Discord with us and you want to talk about DNA, Silkman is our DNA guy. He is a molecular biologist, and he has also worked on the JFK case for over, I know it's over 25 years. I think it was even more than that, as well as he has many, many papers out there on DNA. So he will be with us on a live chat that we will go to a group question and answer over on Discord. Links are being provided. And I'm just scrolling through this, make sure we don't miss some hidden juicy detail, because that has happened to us on other things, such as looking at Lynn Kaczynski's reports. And at the very bottom, we have this evidence list stating a body, about a measurement, a dig site. Yeah, we don't want to miss the last ones. Jim Sensenbrenner, representing Wisconsin's 5th District. So bipartisan rapid DNA passes in the House of Representatives. Oh, it passed in. Ooh. So May 16, 2017, Washington, D.C. Today, the Bipartisan Rapid DNA Act introduced by Representative John Sensenbrenner passed in the House of Representatives. The Rapid DNA Act would establish a system for the integration of rapid DNA instruments for the use by law enforcement to help produce the DNA backlog. Unlike traditional DNA analysis, which can take weeks, rapid DNA analysis permits processing of DNA samples in approximately 90 minutes or less. This technology has the potential to revolutionize the way in which arrested individuals are enrolled in the criminal justice system, shortening the time required for their DNA to be linked to the unsolved crimes, and expedite the exoneration of innocent suspects by giving law enforcement officials a new system that meets FBI qualified assurance standards to compare DNA samples collected at the time of an arrest to profiles in the combined DNA system index system CODIS. And Congress Sensenbrenner, Rapid DNA is a promising new technology and effective tool for law enforcement. It will help quickly identify arrestees and offenders, reducing the overwhelming backlog in forensic DNA analysis, make crime fighting efforts more efficient while helping to prevent future crimes from occurring. It will also save time and taxpayer dollars. Today's passage of the Rapid DNA Act is a victory, and I look forward to it being signed into law. So that's also interesting. Here is the Kentucky one that we went ahead. And that's what they filed. And so they have attached all the different ones. Here's Sean D. Ray's in Utah. Ooh, let's look at this. Lost victims. Huh. The Save UT. Together we make a difference. Interesting. And they do have a video in here. I wonder if we could play it. Nope. Eh, that would be neat. We could probably Google it. It's probably listed so you can look up. Look at all these source materials, you guys. Oh, man, this is just impressive. All right, we're going to keep scrolling. We'll get through some of these paperworks. What's this? Rapid DNA analysis for disaster victim identification in New York City. So that's the New York City one. And results, WTC sample, previous testing, no profile. Okay, so there gives a test sample of what the Andy test probably produces. And that is it. All right, guys. Thank you for joining me on this. That was really long winded, but we did it. Um, let's go ahead and break out chat real quick. Pop it out. Maybe I can make it a little bigger then so I can read it. Because there. All right, let's go. Are there any questions or any discussions? We will be doing our live group question and answer on Discord, and I'm sure that they have been sharing that link with you. Let's get it off of top chat. Let's go to live chat. And there we go. Also, you can get the file that we just read, the motion, out of the library. Now, before we go, before I leave, you guys are all very welcome. I was going to read it anyway. Might as well read it with friends. All right, guys, and many, many supporters. We have a lot of stuff going on today. We knew this was going to be huge today. We do have our daily read, our daily ma'am read coming out at 3 o'clock today, and that will be a premiere. So if you're interested in going on to a live chat, we can do so. So the read will be pre-recorded, and you'll be able to comment and talk along the read. But the big news, you guys, that you've all been waiting for, me too, is this huge surprise we're talking about for tonight. And all I can say is that I think the cat just knocked over something breakable, but that's okay. All I can say about this to give you a clue of the big surprise is, why did Brendan say what he said? And so this big surprise, I believe it's coming out tonight at 7 p.m. on Central Time for United States. So right now, if you want to look at your clock, I can tell you the time for me is 1:11 p.m. And so with that, you can kind of count ahead to, if I was 7 o'clock, it would be 5 hours and what, 49 minutes? And you could add that onto your time. So Brendan Dassey, Tony wrote this, one of our mods. Brendan Dassey is 100% innocent and was coerced into a false confession by experienced and ruthless investigators. Hal Fassbender, a weaker sleep at night is beyond me. Oh, me too. Oh, let's see. Ha! Caught alive, Kelly says. Good deal. Good to see you. World Trade Center. Thank you, Martha, very much. I had not caught that. I appreciate that. All right, guys. So I hope you'll join us today for a daily ma'am read. We are on part 5. And this time you guys are going to really love it because I found a new system that allows me to do crystal clear voice as well as crystal clear reading of the documents. They're very, very clear. So we're very excited to share that. So I will give you guys a goodbye, and I miss you all already, but we will see you later today. Thank you. Thank you, Martha. Okay, guys, I just was reading a little bit of the chat there. I want to call out some people as long as I got just a few minutes. Thank you to Charla because she's been with me on the Rubberducky channel from the beginning. And I know a lot of you have. And it means so much to me because your support is what I'm doing this for, is to get this out there for Brendan and Stephen. So I do have a little bit of concern for their safety. And what we have, you guys, is we have the whole world watching these two gentlemen. And as long as we do, I feel they're safe because the whole world's watching. Kind of like Zellner's mama bear over them. And so we need to continue with the public support, sharing anything. I don't care whose channel it is. If it's pro Stephen and pro Brendan getting home, then please share it. Don't let anybody bother you about um, don't get too wound up in the guilter scene. Do your thing, be yourself, and share all the positiveness in the case. If we don't give attention to these guilters and we just continue to put out the correct information, we will decorrupt the media's take on this case. And you can see that we have a huge tide turning in the ocean of awareness on the public awareness for this case. If you think back 3 years ago, you would say, I think he's guilty. I think he's innocent. And there was these huge battles between sides. And what's come about now is the guilters really have had everything debunked from them. So what do they have? They have no leg to stand on, and neither does the state. So we just go ahead, focus on the case itself, focus on sharing things that, call out the differences in the case, that decorrupt the media, and bring us back online with the correct programming, which is the truth. So the correct programming is the truth. And with that, I'll get off my soapbox, you guys. I love you all very, very much. So much love, and I will talk to you again soon. Thank you all so much. And thank you for caring and sharing. And with that, if you didn't do the crime, you shouldn't do the time. Thank you, guys.